Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Hello everyone, and welcome to the SpringLaw Spring Forward monthly webinars. My name is Lexa Stam, one of the lawyers at SpringLaw, and today we're going to do a 2023 wrap-up and discuss the HR law trends to look forward to in 2024. So if you're one of our clients, you already know that we are employment and contracts lawyer at our virtual law firm based out of Ontario, but we have lawyers outside of Ontario, including Ben, located out of Nova Scotia right now. Welcome to those of you who are new to our webinars. Please feel free to ask any questions along the way. There's a chat function on the platform. Our slides are in the handouts section, so you can download that. We'll be sending out a recording of the webinar afterwards for anyone who would like to dig in a little further. Finally, if you would like more information about our law firm, please come to our website at springlaw.ca, where we have our award-winning blog posts that we post weekly about employment law issues, employment and labor. We have some free resources for you to download that might be helpful, and a link to our monthly newsletter, information about our subscription program, and some of our innovative programs for employers in general. So I'd like to introduce Ben Currie and Lexa Cutler, who are joining me today and helping us talk through it all. So first of all, I would like to acknowledge that we are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, and the Haudenosaunee, and the Wendat people, and that this territory is now home to many diverse First Nations, Inuit, and Métis people. I would also like to note our legal disclaimer that all of today is legal information, and that every situation is fact specific, so please be aware of that. And this is all general information to get you going and issue spot, but then you may want to talk to the lawyer at some point. Okay, so here's our roadmap for today, and then I will shortly hand it over to Lexa to kick it off. But today we're going to talk about the legislation updates that we've seen in 2023, including the Working for Workers Act here in Ontario, and then a couple of pay transparency acts across the country. We'll do a quick case law development summary, especially around the increase in notice periods and how we're really starting to see that old ceiling of 24 starting to get stretched a little bit. We're going to talk about this substratum doctrine that we all learned in law school, but all of a sudden we're starting to see a little more ink spilt on it in the mainstream. So we want to explain what that is and why it matters, and then look at some HR trends that we're going to predict will continue to be an issue for 2024. So Lexa, let me turn it over to you.
Sorry about that. I hit my I hit the camera instead of the unmute, so there you go. Thanks for the intro, Lisa. So yeah, the first piece of legislation we're going to talk about today is the Ontario government's latest iteration of the Working for Workers Act. So these changes came into effect at the end of October, on October 26, 2023. This act amends 3 of our employment standards legislation here in Ontario. So Employment Standards Act, Occupational Health and Safety Act, and the Employment Protection for Foreign Nationals Act. There was a couple other pieces of legislation that were amended, but we're not touching on those today. These are the most relevant ones. So first, let's talk about the amendments to the Employment Standards Act. Probably the most significant change made by the 2023 Working for Workers Act are the changes regarding mass terminations. Now, with the amendments, certain remote workers are expressly included in the ESA's mass termination rules. the mass termination rules under the ESA provide that employees are entitled to enhanced notice periods where 50 or more employees are terminated at an establishment of the employer in any 4-week period. So with the amendment, the definition of establishment now includes an employee's private residence if the employee works from that residence and does not perform work at any other location where the employer carries on business. Under these rules, employers will also need to provide notice of any mass terminations to these affected employees. So why is this significant? Well, it's an acknowledgement by the Ontario government of the changing landscape of work and that many employees now perform work completely remotely. Essentially, remote work is here to stay. So the idea of an employer's establishment being one single office or factory, as it was in the past when these ESA rules were written, is no longer always going to be accurate. So this could really increase a lot of employers' liability when terminating employees. So another change made under the ESA with the 2023 Working for Workers Act was eligibility to reservist leave. So reservists are now entitled to leave to recover from illnesses or injury related to participation in military operations or training, and eligibility for reservist leave has been reduced from 3 months of employment to 2 months of employment. The Working for Workers Act also introduced more strict licensing requirements for temporary help agencies and recruiters to enhance the protection of foreign nationals and to prevent practices such as charging fees to foreign nationals when these help agencies find a work placement for them. Under the Employment Protection for Foreign Nationals Act, there's now a higher penalty for persons convicted of taking possession of the property of a foreign national. And finally, the Working for Workers Act amended the Occupational Health and Safety Act to increase the maximum fine for conviction under the Act for a corporation from 1.5 million to 2 million. So inflation was everywhere this year, clearly. Yeah.
Exactly.
Okay, good morning, everyone. I'm going to talk about pay transparency, which has become a very hot topic throughout 2023, first in BC when it was introduced as a bill earlier this year, and then now most recently in Ontario. So we're going to talk about British Columbia first, since the Pay Transparency Act has actually been passed, so now in effect as of the beginning of last month. The main requirement really with this act is that private sector employers will, and all employers in BC, will now be required to post either the expected salary or wage for the position, or post it as a range if that's more appropriate for how it exists. This is going to apply to a publicly advertised job opportunity as it's defined by the Act. So really what that means is just that it's to a specific job opportunity for a posting rather than, for example, a general help wanted ad. Luckily, the BC government also provided a little bit of guidance, because the natural question from an employer will be, how big of a range can I post? We heard that a lot in PEI when that first came out last year, as the only other province with this legislation in effect at the time. They give examples. For example, if it's a salary, 40 to 60,000 would be appropriate, or hourly, $20 to $30 an hour are the examples provided. But if you just say up to $30 an hour or $20 and up, $20 per hour and up, they say that will not be sufficient to be compliant with the Act. We expect that beyond that, for ranges, it's really going to be a reasonableness standard. So what they don't want to see, for example, is a job pays, $50,000 to $200,000 per year. Clearly, that would be evading the purpose of the Act, which is really to provide transparency for workers throughout the workforce in BC. It's also going to apply to remote positions, which is interesting. It's helpful that they also clarify that as well. So if there is a posting open to multiple locations, and among those is British Columbia, the requirement will catch that as well. So that's important to be aware of, especially as Lexa mentioned, with remote work likely here to stay, and that being utilized a lot more now. Helpful to have that clarified through the guidance documents as well. And finally, there's also a requirement that will prevent employers from asking about pay history from employees. They may, volunteer this information voluntarily in an interview, for example, or throughout employment, but the Act does specifically prohibit employers from asking about that. So we'll just jump forward, and a few other points just to cover briefly in the Act. There's also protection against reprisal. So this really just means that the employer can't discipline or disadvantage the employee in any way. And it specifies some circumstances where that is the case. For example, if they make inquiries about their pay, disclose their pay to other coworkers, or if they make inquiries to the employer about compliance with the Act, or make any reports or complaints under the Act to the director. So that's important to be aware of as well. And also, finally, there will be reporting obligations. There's a very detailed regulation that's been released as well. We won't have time to cover that in detail for the purposes of today, but very briefly, it will require, based on categories, the employer to specify average pay for each of those categories, which are specified based on gender, as that's defined in the regulation. It's not something that's going to happen today. For large employers with 1,000 or more employees, it's going to be November 1 of 2024. And then it goes out from there. So November 1, 2025, if you have 300 or more, November 1, 2026 for 50 or more, et cetera. So basically, the smaller of an employer you are, you're going to have a bit more time to deal with it. But we do recommend considering this a requirement, especially given it's very detailed in terms of what you have to report. And it's going to be a very new requirement for many employers, especially in the private sector. So then following that lead, just 2 weeks later after this took effect on November 1 in BC, the Ontario government then introduced a bill, part of the Working for Workers Act that Lexa referenced originally, which has come through many iterations throughout the year. And within that, it's going to address pay transparency as well. So we don't know quite as much as BC at this point. It is just a bill. It's currently in the second reading, which means it just has a few more stages to pass through the Ontario legislature. So it could change. It could be, revised, and there's no guarantee that it will pass. But at this point, we know that similar to BC, it's going to require Ontario employers who post a public job posting to specify, once again, either the compensation or the range of compensation for a position. And they've also noted that we will expect more by regulation to know, similar to BC, if there's clarification as to what that means and any potential exclusions as well.
Mm-hmm.
And finally, just once again, this is going to be a big change for employers. BC and Ontario are very large provinces to date. Before this year, it really only was in PEI, which we appreciate probably won't affect many, if any, on the call today. So very important to be aware of, and definitely something new. So we'll certainly be keeping an eye on how things work in Ontario and keep everyone informed if that's something that progresses. But just to reiterate that this is now law in BC as of the beginning of last month. So certainly for our BC clients out there, it would be important to inquire about this just to make sure that you're compliant with your practices and your postings currently.
Thanks, Ben. No, I just want to add that the reason, or one of the big reasons why this pay transparency legislation is starting to roll out, and we started to see a little bit in the States. California rolled out something, was one of the first states to do that. It's because in the absence, if we don't have this kind of legislation, then there's this big risk of perpetuating pay inequity, especially for women. And so, asking women what they made at their last job, if it was a crappy pay, you're not going to double that. You're going to try and see if you can pay close to their crappy pay from their underpaid salary from the last job. And it just perpetuates this pay gap between men and women. That's a really big part of what's behind it in the first place. So even if legislation doesn't apply to you in your province, or you're in Ontario and it's not technically a requirement yet, it's critical to try and avoid any questions around what people made at their last job, and pay what the job is worth, pay what the market is dictating, as opposed to what you can get away with inadvertently by underpaying women in the workforce. Ben, did you run across any commentary on that when you were looking at the pay transparency legislation work at all?
I think it's a practical consideration, especially in BC where there are those detailed reporting requirements. So as an employer, you're going to have to justify why you're paying someone of a certain gender different than someone else. And I use that term just as it's defined in the legislation specifically, but just goes back to what Lisa mentioned. It may be better to be proactive. It's expected that this will go forward in Ontario anyway. So it's a good idea to start to be aware of these requirements, which look very similar across the 3 provinces where they've been introduced. So definitely a good idea to be familiar with them and not be unfortunately then trying to justify why there may be differences, especially under the reporting in BC, is to, trying to explain why one person's getting paid different than another if they're really doing the same thing with similar seniority.
Yeah, and we've had the Pay Equity Act in place for probably almost 2 decades at this point, but that's comparing the pay in a similar job, so or a pay in comparable jobs. So if you're a janitor and your receptionist, are they, you're comparing, if one is predominantly male and one is predominantly female historically, are you paying one more than the other? That's equity amongst your different classes of jobs. So it's a different legal analysis and a different application. This is looking more, I think this probably in part comes out of the fact that the pay equity didn't address enough of the pay gap, and this is, sort of another attempt to address it. So for those that are familiar with pay equity and the analysis that goes with that, if you're doing a pay equity project on all of your roles, it's different than this pay transparency piece. All to the same purpose, but there is a bit of a different approach altogether on it. Okay, that's legislation, always exciting. We're now going to talk about some case law developments, and I will, for the trends for 2023, Lexa, over to you.
Thanks, Lisa. So this year we've seen a continuation of a recent trend that's been happening over the last few years of judges awarding notice periods longer than 24 months. So the conventional cap, the conventional wisdom amongst employment lawyers is generally that notice periods are 2 years maximum. But the courts have recently awarded more than 24 months to older and longer service employees where certain exceptional circumstances are present. So first we had Millwood and IBM, where the Court of Appeal held that a 62-year-old employee with 38 years of service was entitled to a 27-month notice period. The exceptional circumstances here were that the employee's skills were tailored to the employer's business and therefore not transferable. And this had been his only employer in Canada, and he was dismissed right as the COVID-19 pandemic was shutting down the economy. Next, there was Lynch and Avaya, Canada, where the Court of Appeal held that a 64-year-old engineer with 38 and a half years of service was entitled to a 30-month notice period. Similar to Millwood, this employee's skills were unique and specialized to the employer's business, and though there may have been other opportunities for this kind of work in larger cities, the employee's options for reemployment were very limited in Belleville, which was where he lived and worked. These two Court of Appeal decisions from this year continue the trend we've seen over the last few years, such as the 2022 Court of Appeal decision in Currie and Nylene, where the Court of Appeal found that a 58-year-old employee with 40 years of service was entitled to 26 months notice, as the employee, again, had non-transferable skills and had been working with the same employer since she was 18 years old. So what are the exceptional circumstances, to summarize, that will warrant an award of reasonable notice above that 24-month cap that we typically see? So it will be employees with longer service. In these cases, all of them had well over 24 years of service, so they're not falling within that 1 month per year of service rule of thumb that we sometimes see. And they were also in their late 50s or early 60s and highly specialized skills that were non-transferable or catered specifically to their former employer. In these cases, it will be extremely difficult for these terminated employees to find new employment, and the courts were recognizing that. So while these lengthier notice periods continue to be the exception and not the rule, with the aging workforce, employers should keep in mind that 24 months may no longer be the absolute ceiling of their liability for employees. And I know that Lisa will be talking a bit later about strategies for dealing with older employees and any issues that may arise around that.
Mm-hmm. Lexa, we had a question just come in, so I'm going to just interject for a second before we go to the next topic on substratum doctrine. So Leo just put in a question: is there a clear legal definition of the term redundant in Canada, in Canadian law? And if so, how does that definition relate to a termination and the employee's union and legal rights? So I can tell you just quickly, we don't have a formal definition of what is redundant. It's basically a business decision. If the role no longer exists or there's no longer work for this person, an employer can always terminate an employee. It's outside of the union context. An employee can always be terminated as long as they're given the right amount of notice or pay in lieu of notice, and as long as it's not at least in part based on a discriminatory ground. So, an employer can always just say either this role has become redundant or we've, our business is going in a different direction and terminate someone, or it's just not working out because of the performance of the employee. You can always fire in Canada as long as you give the right package. If there's a union involved, that's a whole other webinar because the collective agreement will trump all of it and govern everything. And you do not have a residual right to fire someone in a unionized environment unless there really has been some serious misconduct. And as you can imagine, that it's a very high threshold and a whole bunch of layers there. So that's another webinar. And if you have any specific situation you need some help on in the unionized environment, just reach out to us. Thanks, Leo. Okay, substratum doctrine.
All right, so I'm going to talk about this, and I realize it sounds like a very boring academic topic, but something that would be very relevant to many workplaces, and the impact can be quite substantial. But really what it means by substratum is just that the foundation of the employment contract has really changed. And this occurs, if someone's progressing in promotions through, it could be a title change, but not necessarily, just increased responsibilities and status among their role, that if that occurs, it could be said that the employment agreement, including the termination provisions, are no longer enforceable. And I'll just highlight that through a case that came through the Court of Appeal in Ontario just this past year in ShopLogix. So in that case, it was a very senior employee, a chief technology officer, who signed an employment agreement in 2005 that limited it to 12 months of pay in lieu of notice. A few years later, his compensation went up. There was changes in the structure. He maintained the same title. There was no title change, but very increased in terms of responsibilities and what he was required to do in the role. So eventually he was terminated several years later, and the employer assumed that they could rely on that original contract for 12 months. The court eventually just said, we don't need a title change here. Clearly, the status of this person's employment changed significantly since 2005, and relied on the substratum doctrine to say, therefore, that contract is no longer valid, and they awarded common law reasonable notice, which in this case was 18 months. So quite significant for a very senior employee. At that point, he had been making about $500,000 a year at termination between incentive compensation on top of his base salary. So even that additional 6 months is quite substantial, and something clearly the employer didn't expect, thinking that it had that contract to rely on. So really all the time we see things like status change letters and quick updates as a person may get promoted through the ranks, but you just want to be very cautious with those to make sure they contain the right language, or if not, an entire new employment agreement, just to ensure that something like this is not happening and creating significant liability for an employer. So just something that we wanted to briefly add. And obviously, if you have a termination clause that is enforceable, that you're confident in, you wouldn't want something like this to come into play and nullify that altogether.
Mm-hmm. Yeah, we are starting to really see this doctrine pop up all of a sudden. Okay, let's look forward into 2024 and talk about some HR law trends that we are predicting will really continue to either heat up or continue to be heated as it has been in 2023. So Lexa, over to you about working from home arrangements.
Yeah, for sure. So in our practice, we've seen a real increase in employees making accommodation requests to be allowed to work from home. The timing of these requests is particularly common when employers are implementing a hybrid work policy or increasing the number of days that employees are required to work in the office. So particularly in workplaces where they may have been fully remote during the pandemic and are gradually returning to work. This issue is really popping up. So just as an overview of what that accommodation process looks like, employers have a duty to accommodate the needs of employees who are protected by the Human Rights Code. So the two most common grounds we see when employees make work from home accommodation requests are disability and family status. So employers are obligated to accommodate needs, not preferences. So just because an employee would prefer to work from home, this does not mean that they are entitled to this accommodation based on a protected ground. In order to be entitled to accommodation, the employee must actually engage the protected ground, either by showing that they have a disability within the meaning of the code, or that they have a family-related obligation, such as childcare or elder care, that conflicts with their ability to meet a certain workplace standard, in this case, being in office a certain number of days. If an employee is entitled to accommodation, it's important to note that they are not entitled to their preferred accommodation. So if there was something other than working fully from home that could accomplish the same goal, maybe flexible hours or something like that, the employer and the employee need to work together to find an accommodation plan that works for all parties, keeping in mind the employee's duties, position, and the protected ground in question. So another thing to note is that employers can ask for reasonable proof and employees need to cooperate. I know this can sometimes be awkward, and HR folks I speak to are often really reluctant to do this, but it is sometimes going to be necessary. It's mostly going to be relevant in the case of disability, where employers are entitled to sufficient medical information to understand first whether the employee has a disability and how it restricts their work obligations, and determine what kind of accommodations may be appropriate. Employees need to cooperate by answering questions and providing the information about their restrictions and limitations. In the case of something like family status, employees need to provide their employer with the information needed to understand how the employee's family status affects their job performance and what accommodations may be appropriate, and to demonstrate that the caregiving responsibility is a need rather than a personal preference. So employers only need to accommodate when a protected ground is engaged, as we've discussed, and the accommodation would not cause undue hardship. So there's very little post-pandemic case law, within this new normal that we're living in on these issues, but employers should be mindful that establishing undue hardship, depending on the employee's role, could be difficult, especially if the employee has been working fully remotely successfully since 2020, or if the employee was hired in a remote role and the job duties do not require them to be in person. So this is obviously going to depend on the employer's business and what the nature of the role is, but it can be difficult, and this might be the hurdle that employers have a difficult time getting over.
Mm-hmm.
So handling accommodation requests, as I've said, can be tricky. So how can employers be prepared? Employers should ensure that they are being thorough, documenting all the steps they take throughout the process, and engaging in a good faith assessment of employees' requests. So even though I've just laid out, all these parameters that employees need to meet, the best practices for employers to accept those accommodation requests and assume that the employee is making them for the right reasons and that they're telling the truth, and that's the best place to start from when dealing with these, and then you address them as they develop. But employers should also make sure that they have policies in place, such as remote or hybrid work policies and accommodation policies that set out the processes and expectations for employees in these situations.
And Lexa, just to clarify, I know what you meant, that employers, it's always a good practice to accept the request. It doesn't mean agree to the request, and I know that's not what you mean, but I just want to make sure that's clear. At face value and good faith, taking it, take in the request and then do your assessment, your analysis, based on what information you have. But there isn't a sort of a default requirement to accept it at all. And we're seeing so many of these, of people who don't want to commute, who moved away during the pandemic and to a beautiful small town instead of a tiny little place downtown Toronto, for example, and they don't want to commute anymore, and it is not hard to get a doctor's note to say that it's stressful to drive along the 401, because of course it's stressful to drive along the 401. So it's not hard to get these doctor's notes for the employees. And so this is a really hard area of law, and we're not going to see it go away anytime soon. It's going to only increase. The practical issue that employers are facing is that when accommodation requests are not granted, people walk. And so it's a talent retention issue at this point. And, in areas where there's a real labor shortage, and we're starting to see that shift a little bit, but a year ago, there was such a hard labor shortage in so many areas that employers couldn't afford to let people walk. And so there was a lot more compromise than was desired, either for, the business's convenience or the business needs. So this is a brand new complicated area that most of the concepts existed pre-COVID, but the volume of it and the consequence of it is definitely a post-pandemic issue. Okay, AI in the workplace. Lexa again pushed. I think you clicked the wrong. There we are. Okay, don't go away. So AI in the workplace. It is all the rage. We're all reading about it, and its impact is only barely being felt. But it absolutely is and will continue to transform workplaces in the same way that introducing the phone or the typewriter or the computer all transformed workplaces. It didn't replace people, it just transformed workplaces. We're seeing that happen as we speak with AI. And that's a whole webinar unto itself. So for today, I'm just going to talk very briefly on one slide about this trend going into 2024. First of all, some of the basic uses that we are seeing it across the board. And sometimes, people aren't even aware that there is AI driving the software they're using behind the scenes, for example. But day-to-day things like talent acquisition programs for sourcing or recruiting or evaluating or ranking your CVs that are coming in, and communications with candidates. So we're definitely seeing AI being used in the recruitment world. In the marketing world, absolutely. We're seeing for job descriptions or job postings and content creation in general, lots of AI starting to get used there. And then just general process and work automation, administrative work automation in workplaces. We're starting to see a lot. Both Google and Microsoft are really embedding, functional AI functions in things like chats and texts and emails and reading voice to text accurately, and then summarizing meetings, for example. All of that, obviously dictating technology has been around for a couple of decades now, but this extra layer now of being able to read it and summarize it. If you are lawyers are definitely using a lot of it in their research now for case law summaries. Doctors are using it for summarizing patient notes, for example, debugging codes for coders. We're certainly seeing it in a lot of different workplaces. So the trends for 2024 is keeping up with your employees' worry about all of this. So for many employees are embracing it, they're excited, they've read all about it or watched it on the latest Star Trek episode, so they're super excited. But for many employees, they're worried about the robots taking over and what's going to happen with their job. So managing the insecurity of your workforce, I think will be a real trend that HR is going to have to deal with in 2024. Really digging into any training about just what is AI. It's it is not replacing humanity, and it still is most effective when there is some sort of human judgment embedded into the layer of AI functionality, and reassuring people of that, but training people and helping them understand where AI may fit into their role in this workplace in general, and to be able to use it more. A big trend we're going to be seeing is more integration of AI to augment all of our work, all of it, increasing our AI-powered workflows, for example, chatbots on websites, customer service in general, I think is really being boosted by AI. Analyzing data, marketing data, customer data, a lot of basic functions that people are doing. AI will help augment all of that. And then any sort of repetitive tasks and workflows. So I think workplaces are really, in 2024, we're going to really see this augmented work concept as opposed to replacing. Who knows? But that's my prediction, is that humans aren't going away anytime soon. It's too early on in the application of AI in sort of a front customer or public-facing function so far. Although, ChatGPT just took off like crazy really quickly. So, everything, tech moves so quickly in an exponential way. So we'll see what happens. The big trend that I hope we all really start to dig into in 2024 is building out more AI governance. And so we're definitely seeing, Silicon Valley and the big tech giants being held accountable for the beasts that they are unleashing onto the public. That we all rely on heavily and want, but that there are big gaps of governance on all of where AI is going in general. So in workplaces, things like IP, who owns the content that people are putting into any sort of AI tool, its confidentiality being breached by inadvertently using patient names or client names or customer names. And then the big picture ethics, right? How much of it is using other people's work, are tied to this confidentiality and IP piece, but how are we using it? How are we replacing any sort of human judgment with AI and machine learning, machine predicting? Lots of really fun issues to unpack there over the coming years. And so we're going to start to see a lot of this get a lot more airtime in 2024 and have this direct impact on workplaces. It's not just an academic science fiction thing anymore. The next trend for 2024 is, and this has been going on for a little bit and will continue to go on well past 2024, is dealing with our very long service employees, who by definition are likely also older employers. So there's this succession planning employer trap that we are often dealing with when we're talking to employer clients. The employers feel trapped because you can't ask your employee, as an example, let's say we have an employee who's 68 years old, has been with you for 30 years. You'd like to know what their future is looking like. When do they want to leave? Do they want to leave? How long do they plan to work? Many are waiting for their package, which we now know is going to be at least 2 years, given Lexa's comments earlier. So, there's this trap that employers feel themselves in, where you can't ask about retirement because of age discrimination risks. So you don't want to be asking them, hey, when do you plan to retire? Because the second you do that, you're exposed on a human rights ground. You can't start reducing their hours or their role if their performance is declining, because now you're looking at a potential constructive dismissal risk. You can't fire older workers to bring in fresh blood because it's good for the business or because it's part of your business plan, because again, you're looking at age discrimination. So how do we, the boomers aren't retiring. I can say this as a disgruntled Gen Xer, the boomers aren't retiring, and so we still have a pretty top-heavy workforce in many industries. So what do you do? How do you plan? So a couple of things. First of all, you can always address and hold all of your employees accountable to the performance requirements that they're supposed to be making within their job. So you can always deal with legitimate performance issues that employees may be having, regardless of their age. If where this tends to come into play, partly from a stereotype point of view and partly reality, is if your business or the workplace or the role itself has evolved, is the employee keeping up, right? And we just talked about AI. Are they keeping up? Employees have to keep up, or you exit them, right? And so how do you address that? It's always a matter of being super careful not to talk about their age impacting their inability to learn new things or evolve, because it's factually inaccurate. I think it's an old school stereotype that older workers will not learn new stuff. It's just not true. Go on TikTok and start looking up seniors who are on TikTok, right? It's an old school stereotype that older people don't want to keep up with technology. And so check in on those stereotypes around whether or not they're prepared to keep up with technology. It may not be true. It may be they're just a crappy performer for other reasons. And so check in on that and hold people accountable to the benchmarks of the performance. For these old school stereotypes, HR is usually pretty awake to these issues. Check in on your frontline managers and supervisors, though, who may be feeding back all kinds of opinions and personal views on whether or not this person's any good, this older worker, they're not keeping up. Is that true? Is it again another performance issue? Is it training they need, because they've been at the company for so long, as opposed to age itself? In which case you have a lot more flexibility, right? You can hold people accountable to their role if they haven't been performing it well, regardless of how long they've been there. But as soon as you touch on this age issue, you start to get into hot water. The third way to deal with older workers, and I get so annoyed when I hear clients talk to us about how they were asked about, don't you really want to hang out at the cottage a little more? Wouldn't you like to spend more time with your grandkids? As opposed to asking your worker in a regular performance review, hey, where do you see yourself in 5 years? You can ask any of your workers that, right? You can ask them about their career goals, but don't then start asking about, well, wouldn't you like to slow down a bit and go to the cottage more? And for some reason, so many of those requests are women clients in their late 50s who are nowhere near ready to retire and being sort of shoved into that. And you can see all these stereotypes being applied. So be careful. You can talk about career goals. That's a great way to start talking about what may be a long-term plan for them to do your succession planning, but don't throw in this garbage around, them not wanting to work, because that may not be the case. And finally, working notice is another way to think about dealing with your longer service employees. If you have someone in front of you, like the example I gave, someone who's in their mid to late 60s and has been there for 30 years, if you give them it and you otherwise trust them and they're doing okay, but you need to start some succession planning, an option is to give them 2 years of working notice, and then you're largely done. It's a lot more complicated than that when you're rolling it out, but it's one of the options to consider is working notice for people that you'd like to exit at some point, and to start addressing head on the really big termination liability that you're facing otherwise. And working notice is the same equal weight as paying out that notice in lieu. So it remains an option. If you're in Ontario, there's severance pay, which has to be cash, so just not notice. But so again, make sure you get advice on what is all part of that working notice. But the working notice itself can really deal with a very big chunk of all of this, and it's nothing abrupt. It can be a longer term thing. Many employees hate working notice, just as a heads up though, because who wants to work if you know you're being fired? But it's still, if you have these really great conversations and someone is looking to wrap up within a couple of years, this could be a way to do it. So there's lots of options, but it's not easy. We have a lot of clients that are facing this issue, that it's how do you in a decent and dignified way, deal with succession planning with your older and very long-term service employees. This is a really hard area, and this is not going to get easy anytime soon because we still have such an older workforce at play. Okay, over to you, Ben, for managing mobile workers.
Yeah, so switching gears a little bit here, we're just going to briefly cover a few hot topics in the area of mobile workers. The first one being an employer of record, which is something that we're seeing a bit more recently in the past few years. This is something that a company will do, for example, if they're located in a different country, for example, in the US, and they're going to have a workforce in Canada. So they might engage an employer of record rather than setting up a corporate entity in Canada. And that employer of record, the idea is that they'll become the legal employer. They're the ones that will have the employment contract, excuse me, with the employees, and they'll handle the local issues such as payroll, human resources, compliance with local employment laws, etc. Just given the fact that that US entity may not have that expertise and would rather have someone local with that understanding and expertise to handle that for them. And that will typically be pursuant to a corporate contract between the company and the EOR, the employer of record in this case. So as I mentioned, there is more of an uptake of this in recent years. So it's unfortunately not well tested with case law. One concern is, although the idea is that the employer of record will become the legal employer, there are common employer doctrines in other areas of employment law. So there's always a bit of a concern there that the company engaged in the EOR might still carry some of that liability. So we'll be very curious to see once we get more decisions on that, it becomes a little bit more tested to give us some more guidance. But of course, the commercial agreement between the company and the employer of record is really going to govern like any contractual dispute. So of course, it would be very important to be aware of the terms that are in that, so you know exactly what you're contracting for and what you're expecting to get in return, especially in terms of liability if an employer is using this type of service. Another option that's a little similar to an employer of record is a professional employers organizations. Often companies will provide both services, but they are a little different. It's typically more clear in a professional employer organization arrangement that the PEO will become a co-employer with the company engaging them. So rather than stepping in the shoes and becoming the legal employer. So in this case, it's very likely that termination liability, for example, could be shared. But again, that would likely be spelled out in the commercial agreement. So once again, the contract between the parties is really going to govern. But we are seeing this a little bit more often lately. So a bit of an interesting topic, and we'll be very curious to see how it unfolds. So another issue that's come up, especially with remote work since the COVID-19 pandemic, is where we have a workforce that are working in different provinces or potentially even different countries, which employment standards is going to govern. Generally, it's going to be the province that the employee is currently living in and performing work from. There are a few nuances to that, but within Canada, that's generally the understanding. There's a case mentioned here that came out of Nova Scotia. In this case, the employee was in Nova Scotia, but the employer had no presence here. The employer was located in Ontario, had no corporate headquarters or any office whatsoever, and the employee was living and working from her home remotely in Nova Scotia. There is a Supreme Court of Canada decision that was applied by the board, really along the lines of a sufficient connection test. So, you know, there's various factors that will be considered, but it did seem as though where the employee resides and performs the works from will be a very dominant factor in that analysis, which leads to that conclusion that generally that will be the case. This test was also endorsed in a recent decision out of the Supreme Court of Canada last month that dealt with a securities tribunal. So a little bit of assurance that that'll still be the analysis that's applied. But we know this is a hot topic, and it'll be curious to see some post-COVID case law just to see if that's still the case or if there's any further nuances that we need to be concerned about, and making sure that employers are aware and making any adjustments to contracts, et cetera, as necessary. So really, this is going to hinge also on tax law. I mean, employment liability is one thing, but generally employment standards are fairly similar across provinces, and it's really going to come down to tax considerations, especially when you get into a situation where your employees are going to work internationally outside of Canada. There could be some serious tax liability at play there that you're going to want to be aware of, and really that's what's going to drive this decision. So we would recommend consulting a tax lawyer in those circumstances.
Yeah, and tax drives so much of it. I mean, like you say, it's the bigger liability. Ben, we just got in a good question. Can you use EORs in a unionized workplace? We have an employee who recently moved to the UK and that we would love to retain them. So with the EOR or PEO in this case, would that be an option in a unionized environment?
It's a good question. I'm not aware of any. The ones that I've seen so far were in the non-union context. So I'm not aware if there's any EORs out there that would be willing to get into that type of arrangement. The idea in that situation is that they would likely step in and become subject to a collective agreement. That may go a bit beyond the bounds, but it's a great question. So that would really come down to what the service offerings are from the EOR and if they're actually willing to take on that liability. Generally, they appear marketed more towards the non-union context. There's a lot of talk about EORs will advertise that we engage local employment lawyers to vet our contracts and make sure that employment contracts are up to date. I haven't seen any that reference services related to labor relations. So I'd be a bit surprised if that exists right now, but it may be something, if not, that expands into the future. But definitely, a lot more to take on in the unionized context. So that's a good question.
And because the EOR would not be at the bargaining table and they wouldn't be a party to that collective agreement. So nothing's impossible, but it would be a complex contractual arrangement to sort out up front to figure out how they are an employer without having any sort of liability on the successor or common employer fronts. So I don't know.
I think that's a tricky one because normally in the non-union context, the EOR would be the party to the employment contract. So yeah, as Lisa mentioned, it would get very tricky to then consider how that works in the context of do they become a party to the collective agreement and then be responsible for bargaining, et cetera. It seems like an awful lot for the company to hand over to the EOR in that case. So that might be a tricky one for sure.
Yeah, I mean, having somebody as an independent contractor outside of all of that, if you could carve it out of the collective agreement somehow, if it's only one person, rather than opening a giant can of worms, if some sort of contractor agreement could happen, that I know that's hard in a unionized workplace if you're outsourcing bargaining work, but Mandy, give us a call if you'd like to chat further about it. That's a fun issue that we would probably love to sort through with you. Okay, so let's start to wrap up here. If there's any other questions, feel free to send them through. Some key takeaways so far are that Canada is an employee-friendly jurisdiction, and we have a lot of clients who are headquartered out of the States. And when we talk to the sort of the decision makers out of the United States about what's going on at their local operations here in Canada, they're often a little bewildered about how bananas it is up here of how employee friendly everything is, but it is what it is. And the cases and legislation continue to develop in that direction. Working from home is here to stay, and it's increasingly now embedded in our actual laws, not just case law. We're starting to see it roll out in our Employment Standards Act updates. Contracts continue to be the foundation of employment relationships in Canada that need to evolve with the employee's role. Otherwise, we're running into these substratum doctrine issues, where if there isn't, and for anyone who's from the United States that's on the call, if the employer isn't carefully writing down what the contractual terms are, the court will do it for you, and they will always do it in a more employee-friendly way. That's the common law exposure that you have in a wrongful dismissal case. So the substratum doctrine really is not, like you said, like Ben said, it's not just an academic thing. It really is a practical application. AI and tech will continue to transform the workplaces, requiring updated policies and skills across the board and communications about all of that. And then finally, managing your older workers and your mobile workers, that's going to continue to keep all of us busy in 2024. There's a lot of untested areas, especially around the mobile workplace. And we just are heading into this real crisis, is probably a bit dramatic, but this crisis of older workers and figuring out, I mean, I've certainly talked to employee when we're on for the employee, they're waiting for their package. They want that 2-year payout. So why would they resign and give up the potential entitlement to 2 years. So there's an interest on both sides to wait for the other person to act. So we'll see how this starts to unfold over the coming years. Lexa, Ben, anything to add for any takeaways from today?
I think that's a good wrap up. Definitely a continuation of what we saw last year, but yeah, certainly lots of important legislation and case law developments that we've seen, and AI and tech, as Lisa mentioned, is certainly taking off as well. So.
Okay, well, look, if there's any other questions, feel free to follow up with us afterwards. Let's conclude the webinar for today. Ben and Lexa, thank you for all the great content that you bring to the table and that you presented on today. Our next webinar is going to be on January 15. We always do these on the third Wednesday of the month at 10:30 in the morning Eastern Standard Time. We're going to be next month, the topic will be working with your external employment lawyer, and we're going to have a special guest, an HR professional that will be joining me, and we'll have a conversation about how do you collaborate, with your outhouse lawyer, as I've heard it called as well, not your in-house, but your outhouse lawyer, to help reduce costs and bring efficiencies to the overall process. What can you expect? What can you not expect? So that's going to be our topic next month. Feel free to come to our website and register today. If you can't make it on that day, you'll still get the recording after, so feel free to sign up. For any other information about us or the webinars, just come to our website again, springlaw.ca. We'd love for you to follow us on our social channels, Facebook, Twitter, LinkedIn, Instagram, TikTok, YouTube, all of it. And sign up with our monthly newsletter to stay up to date. We collect all of our weekly blogs and then add a bit more and send that out once a month in our newsletter. So we do our best not to spam in between that. So feel free to join up for the newsletter. And that's all for today. Have a great holiday for people heading out, and a great rest of 2023, and all the best for 2024. Thanks for joining us.